Welcome back to Advocacy Alchemy with Professor Ross. Today we have a good one, guys. A courthouse is meant to be a place of law and order, but what happens when emotions take over and it turns into a battlefield? Recently, today, at the Pulaski County Courthouse in Arkansas, a fight broke out in the corridors, forcing courtroom security to step in and restore order. The altercation involved the mother of Davin Chance Bizzell-Holmes, a 15-year-old murder victim who was present for the court proceedings of the suspects accused in her son's death. With emotions running high, tensions erupted into a physical confrontation right inside the courthouse. Today we're going to break down the legal consequences of fighting in a courthouse under Arkansas law, the role of courthouse security, and the protocols that are in place, and the broader implications of courthouse violence on the justice system. Let's dive into the footage and see exactly what went down. I will tell you and warn beforehand that it is graphic. No one was seriously injured, but it is a melee. Let's jump in. Now that you've seen the chaos unfold, let's talk about the Arkansas laws that apply to this situation. Courthouses are legally protected environments, and fighting or causing a disturbance inside a courthouse can lead to serious criminal charges. Based on what we've seen in this video, let's break down the potential legal consequences involved. First, you have battery charges, and those are found at ACA, that's the Arkansas Code Annotated, Section 5-13-201 through 203. You have first-degree battery, that's a Class B felony. This is the most serious one. If someone causes serious physical injury to another person, particularly with a weapon or extreme force. You have second-degree battery, and you have third-degree battery. That's really the more crucial one. And to give you some background, second-degree battery simply means it either happens to a person that's over the age of 60 or under the age of, I believe it's 12, or a certified law enforcement officer or corrections officer. Third-degree battery, this is a Class A misdemeanor, okay? This is the one that I believe the people involved in this fight out here are going to be charged with, if there are going to be any charges. If someone's intentionally causing physical injury to another person, that's what the definition of a third-degree battery is. It's used for fights. If anyone in the fight suffered injuries, those responsible could face battery charges. There's also assault charges that potentially could happen. Assault is defined under Section 5-13-204 through 207. All right, third-degree assault. This occurs when a person recklessly causes physical injury or threatens harm. Even if no one was injured, aggressive or threatening actions can still lead to assault charges. All right, that's also going to be potentially a Class A misdemeanor. All right, in Arkansas, Class A misdemeanor is the highest level misdemeanor. It carries up to 1 year in jail and a fine of up to $2,500. All right, let's move into the next potential charge, which everyone potentially may face, and that's disorderly conduct. Now, we talk about disorderly conduct quite often when we talk about Florida cases or Georgia or wherever else we're talking. It's the same here in Arkansas. It's found under ACA Section 5-71-207. This occurs when someone engages in violent, abusive, or tumultuous behavior in a public place, and that all qualifies as disorderly conduct. And once again, like I said, this is a misdemeanor here in Arkansas. A fight inside the courthouse, that definitely, it fits. Number 4, obstructing governmental operations. This is found at ACA Section 5-54-102. If someone interferes with law enforcement or courthouse security while they're performing their duties, they can face obstruction charges, which range from a misdemeanor to a felony. If anyone resisted security's attempts to break up the fight, they could be charged with obstructing governmental operations. Number 5, criminal trespass. This is found at ACA Section 5-39-203. If individuals were asked to leave the courthouse and refused to do so, they could face criminal trespass charges. It's important to understand that this wasn't just a moment of emotional outbursts, okay? Yes, it is that, but it's also an act that has some very serious legal consequences. Now, I will say that what charges happen from this all depends on the prosecuting attorney's office there in Pulaski County. Let's move into our evidentiary standards next. Evidentiary standards are going to be important in this case, just like they are in every case. Anytime that there are going to be police actions involved and eventually some sort of legal system involvement requiring a trial or to appear in court, these standards apply. First, you have mere suspicion. This is the lowest level of evidence where an officer has a vague feeling or a hunch that something illegal might be happening, but they lack concrete facts. Here, security might have sensed tension rising, but had no concrete evidence of an impending fight. Number 2, reasonable suspicion. This standard requires specific and articulable facts that suggest a crime may be occurring, allowing law enforcement to investigate further. For example, if people were arguing aggressively, security might have had grounds to intervene. Everyone here is old enough to have been around when a fight starts. Usually there's some precursor, somebody screaming, cursing out loud, a crowd of people moving toward the location where the fight is happening, or people moving away from where everything is happening. Number 3, probable cause. This is the level of evidence necessary for an arrest. It requires facts and circumstances that would lead a reasonable person to believe a crime has been committed. For example, once physical contact occurred, there was clear probable cause to make arrest. Number 4, preponderance of the evidence. Remember, this is used in civil cases mostly. This standard means the evidence shows something is more likely than not to be true. For example, if this case goes to civil court, the judge may weigh evidence based on a more likely than not standard. If someone was injured and they wanted to sue the other person who injured them, they could take it to civil court. Number 5, clear and convincing evidence. This is a higher standard than preponderance. This level requires evidence that is substantially more likely to be true than false. Remember, we usually say about 75% of the evidence needs to point to one side being true. For example, if someone claims self-defense, they must prove their case with substantial supporting evidence. Number 6, beyond a reasonable doubt. This is the highest evidentiary standard used in criminal cases. It requires that no reasonable doubt remain about a defendant's guilt. Prosecutors must prove without a reasonable doubt that the individuals involved in the fight intended to commit battery, disorderly conduct, or obstruction of justice. All right, next we'll move into the role of courthouse security. So, how should security have handled this incident? Arkansas has specific court security protocols, including court security officers, and these are trained law enforcement that are assigned to maintain order and prevent violence. You have security assessments. Courthouses conduct threat assessments and regular training to deal with high-risk situations. You also have restricted access areas. Some courts limit access to emotionally charged cases to prevent outbursts. Here, in the video that we watched, the security personnel, they seem to have acted quickly. There were 4 or 5 people that were either police officers or courtroom security. Now let me tell you this. Now, courtroom security, the guys with the neon on, the neon vest, all right, they work for the sheriff department, okay? That's how it works. Here in Arkansas, most of our bailiffs are deputies at whatever county we're operating in. So here, those people with the vest on, they are deputies with the sheriff department. They're paid through the Pulaski County. So here, it seems the security personnel acted quickly, but could additional resources and additional measures have prevented this fight altogether? Let me know what you think. Now, let's step into the jury's shoes. Imagine you're sitting on a jury deciding the outcome of this case. And ask yourself, does the video show clear aggression from one side, or was this a mutual fight? Next, should emotions be considered in sentencing? Or is the law the law? Next, would you convict someone of disorderly conduct if they were only defending themselves? Think about it. What would you decide this case was in your hands? Now keep in mind the video we saw was a bystander who had recorded it. Now the Pulaski County Courthouse is full of cameras, all right? So the jury will see the full incident from when it started to the results, if there are going to be pending charges. And then also the jury would hear from the officers themselves and any other people who are involved that will potentially be subpoenaed to give testimony about what happened. This case isn't just about a courthouse fight. It's about how strong emotions in high-stake cases can escalate into legal trouble. The fight at the Pulaski County Courthouse is a reminder that courthouses aren't just places of justice. They require order and security. If you find yourself in a tense legal situation, stay composed and let the law work for you, not against you. What do you think should happen to the people involved in this fight? Should they face serious charges, or should the court show leniency? Let's discuss in the comments. Remember, this is Advocacy Alchemy, and I am Professor Ross. I'll see you tomorrow. You all have a good day.